Judge Ireland recused on this one?
Mr. Magler? I want to make sure I'm pronouncing your name correctly.
Magler, Your Honor.
I was
Thank you. Good morning. If it please the Court, my name is Michael Magler, and I represent the appellant in this matter, Leon Bleich. Mr. Bleich began employment with Maimonides School on March 1st, 1988. Maimonides School is an Orthodox Jewish religious school that's located in Brookline, Massachusetts. And if I might just refer to part of its articles, which appear on page 219 of the appendix, to maintain and operate a school for the dissemination and teaching of Hebrew religious and literary works based upon Orthodox traditional Judaism, together with English secular education in coordination with and under the supervision of the public school authorities, and covering all subjects taught in the elementary and high school grades of our public schools. Mr. Bleich worked for Maimonides for approximately 14 years when he was terminated on October 18, 2002. Although during that time, Mr. Bleich had no formal title. Towards the end of his tenure with Maimonides, he was given the title of Tuition and Scholarship Administrator. In that capacity, Mr. Bleich generally did tuition billing for the school. He did tuition collection, and he also was responsible for accepting scholarship applications, evaluating the scholarship applications based on guidelines that had been given to him by his superiors, and awarding scholarships.
I take it he had no knowledge that, or maybe he did, that the school wasn't paying into the unemployment fund.
Your Honor, no, I don't believe he did have any knowledge of what the ramifications would have been if he was terminated.
Well, that's not the question I asked. Did he know whether they were paying into the fund or not?
I do not believe that he did know whether or not they were paying into the fund, Your Honor. We're before this Court today based on the undisputed fact that but for the division's qualification of Maimonides under Section 6R, 151A, Section 6R, as an exempt organization, that otherwise Mr. Bleich would be able to collect unemployment compensation. He would otherwise qualify but for the exempt status that's been found. Now, for the purpose of exempting an employer, again, we look at 151A, Section 6R, where it defines the term employment. And it says the term employment shall not include services performed in the employ of a church or convention or association of churches or an organization which is operated primarily for religious purposes and which is operated, supervised, controlled, or principally supported by a church or convention or association of churches. Obviously, in this case, when we're referring to a church, we're looking at a temple in this case. Before I frame the issue that's now before the Court, I'd like to point out to the Court another undisputed fact, that being that both Maimonides and the division acknowledge, and I quote from the Maimonides brief, Bleich is correct that Maimonides School is an independent school that is not operated, supervised, controlled, or principally supported by a church or convention or association of churches. Therefore, Your Honors, given that Maimonides and the division have acknowledged...
Is that an agreed statement of facts?
Yes, Your Honor.
Undisputed fact, or is that a conclusion of law?
No, Your Honor, that is a statement of fact as I've read the quote. That is an acknowledgement.
But what is it, under that conclusion, what does principally support mean? Are you suggesting financial support?
Under the case law that's been cited, for example, the Nampa case, principal support could be financial support. It can also be moral support, Your Honor. However, I don't believe we get to that issue based on the fact that Maimonides has told the division and has now told this Court that they don't qualify under that second scenario. And the reason why I started...
Well, is it they don't qualify because they interpret the statute one way and we might interpret it another? Or does DET share that position as well?
Yes, Your Honor. I believe in their brief they also acknowledge that statement by Maimonides.
Now, do they share the position that... that the school does not fall into the category of being principally supported.
Obviously, I can't answer for them, but based on what their brief says, they agree with that statement.
So what are you saying? They made a concession that
Yes, Your Honor.
that ends this case in your favor?
No, Your Honor. What I'm saying is they made a concession that the second test that's set out in Section 6R does not apply. So it's left for this court to consider.
Well, that means they don't qualify for the exemption.
No, Your Honor. What's left for this court to consider is the first part of Section 6R, which is service performed in the employ of a church or convention or association of churches.
What do you do with the and? And which is operated.
And
That's the second part of the 6R test, Your Honor, that you're looking at.
No, I understand, but if you're saying they've conceded that they don't meet the second part,
Yes.
well, then they have, and you've got an and. You don't have an or, you have an and.
Not with the first part, Your Honor, of the 6R test that we're looking at, service performed in the employ of a church or convention or association of churches.
Everybody does agree that the school is not a church, it is not a convention, it is not an association of churches.
Well, no, Your Honor, that's my point, and that's the issue before the court. If you look at Maimonides' brief, the thrust of Maimonides' brief now is that they qualify as a church or as the Jewish equivalent of a church.
But that was not DET's analysis.
DET's analysis, Your Honor, is that they agree, again, with the statement that they don't qualify under the second part of the second test under 6R. But what both DET and Maimonides say to the court in their briefs is that even though we don't qualify, we do, and here's why. That I have to leave to the court to reconcile the fact that a party is saying, we don't qualify under this section, but we do, which, again...
But isn't the argument that's being made is that there are constitutional overtones here, and that we either rule on it on constitutional grounds, or because of those constitutional concerns, we should interpret this exemption and its language in a way that would avoid constitutional problems.
You were correct, Justice Sossman, that, yes, Maimonides does make the constitutional arguments, and they made them in the lower court. DET, in their brief, agrees with us, as the appellants, that there are no constitutional issues here. I would also direct the Court's attention to the Supreme Court decisions that have been cited, to Ursuline Academy, and to the Kendall case that have been cited, and I would also direct the Court to the majority of other courts that have ruled on what's the federal equivalent of Section 3309B1B. All of those courts basically start their analysis by saying, we don't have a constitutional issue here. This case can be decided on statutory grounds, and we are going to decide this case on statutory grounds. All of those courts don't even touch the Constitution issue because they find right at the outset they don't have to, and they've never found that.
Are you saying that that you could have an entity, that provides for the instruction of Jewish youth and the tenets of the Jewish religion, which is done not by I've got to get the statute in front of me, church or convention or association of churches or an organization which is operated primarily for religious purposes?
Correct, Your Honor, because that's the primary distinction that comes out of the St. Martin case from the Supreme Court, that it looks at separately incorporated entities and entities that are not incorporated separate from the church or the church equivalent. So yes, Your Honor, that's exactly the point. And then NAMPA goes on to identify three different categories of possible institutions that they could be. One of the categories is an entity that is not separately incorporated from the church. Another institution is another category is an entity that is separately incorporated from the church, and then NAMPA also identifies a third entity, which is an entity that is separately incorporated from the church or the church equivalent, but that might also qualify as a church in and of its own right. That's what I think we're dealing with here, and that's what Maimonides is arguing before this Court in their brief, that they qualify as a church. And I would submit to the Court that under no circumstances would Maimonides qualify as a church. And in substantiating that position to the Court, I'd make several arguments that come directly out of the record. Probably the primary argument I'd make that Maimonides is not a church is the fact that in the record, Ms. Joseph, on behalf of Maimonides, who appeared as a representative of Maimonides, testifies over and over to the DET to the division now.
This test has two parts, am I right? The first is service performed in the employ of a church, and then the control factor.
No, Your Honor. When you refer to this test under 6R, under 151A, Section 6R.
Am I misreading it?
Yes, Your Honor. 6R has two tests, Your Honor. The first test under 6R says that if you're a church or convention or association, then you qualify.
Yeah, okay, or.
Or then the second part of the test, Your Honor. And as I've said to the court.
Okay, so was the first part even raised below?
Yes.
The first part was raised below, Your Honor, but the decision of both the division and the decision of the Brookline District Court was based on the second part of the second test, Your Honor, saying that Maimonides is operated, controlled, supervised, and principally supported.
Could I ask you to turn your attention to the, principally supported by? Because that seems to me to be, in terms of, where the, however you say people have made various concessions on it, that seems to me to be the nub of this problem. To what extent or in what manner is Maimonides supported by temples and synagogues in the area, be it financial support or other types of support that might satisfy this test?
With all due respect, Your Honor, I disagree with you that it's not the nub, because with the point that I'm trying to make to the court is the court doesn't even get to that test because it's not before the court.
But your theory that it's been conceded, I understand. You have
But it hasn't been conceded by the DET.
It's not been conceded by
Yes,
the
Your
DET,
Honor.
as I read their brief.
Yes, Your Honor, I believe it has been conceded.
Okay.
I believe it has.
Assume for purposes of argument that we disagree with you on that and say that DET has not conceded that point. Could you address it?
Sure, Your Honor.
What can qualify as the kind of support that might be at issue?
Absolutely, Your Honor. As the Nampa case tells us, because the Nampa case actually deals specifically with that issue, because in the Nampa case, the court finds that Nampa does not qualify as a church. However, it does qualify under the second part of the equivalent of 6R. The Nampa court says support can be financial. It doesn't have to be. It says support can be moral. So in this case, if we go back in the record and look, Your Honor, that goes against Maimonides being the equivalent of a church, being a temple or a congregation in and of itself. We see, for example...
It doesn't have to be a church. It just has to be supported by.
Right.
Or principally supported by. It seems to me the argument would be, or the theory would be, as I gather, that the school recruits its students from local temples, synagogues, has contacts with them, and the argument made that, if it didn't have that source, that relationship, that the school, in fact, probably wouldn't even exist.
Let me start with that point.
Why isn't that principal support?
Let me start with that point, Your Honor. First of all, there's no evidence of that even in the record. The evidence in the record states that Maimonides is independent from all the other Orthodox Jewish congregations in the area. The record states that there are upwards of 50 Orthodox congregations in Massachusetts that Maimonides recruits from the preschools and from the rabbis.
Mr. Magba, could I ask you, I don't mean to cut you off, but I'm looking at the examiner's conclusions, because I sort of go back to where,
Is that the DET's conclusion, Your Honor?
Yeah. May have been, slightly, I just don't know. He goes through this, which I think goes to what you were talking about. He's worried that we can't deal with this situation as a hierarchical church because there are no hierarchical Jewish churches. That's fine.
Well, I could address that issue too, Your Honor, because I believe that's an incorrect conclusion also.
He says the school was founded by Orthodox Jews, okay, to further the tenets of Orthodox Judaism, okay, and these people, including the people who continue to run the school, are a, quote, church community as contemplated by the law. What's he referring to?
I don't know, Your Honor, because my first problem with that is this, quote, church community is something that he made up, and he refers to applying the standards.
Well, let me break it down a little bit, the word community. Don't we have here facts that the principal of the school has to be an Orthodox Jew? One rabbi must sit on the board or the school committee. The current principals are rabbis. The school synagogue is led by a rabbi. The teachers who provide the religious instruction are Orthodox Jews. half of the faculty is Jewish. Recruitment is from temples and synagogues and through rabbis. And even though tuitions and fees are used, the school receives and relies on funding from synagogues and the combined Jewish philanthropies. Now, doesn't that make principal support by church organizations?
No, Your Honor. First of all, there's a factual problem there that the school gets principal support from CJP. In fact, if you go to page 218 of the appendix, Your Honor, the latest statements are available for 98, 99, and 99 and 2000.
I didn't say they get principal support. I said they get some funding from synagogues and the combined Jewish philanthropies.
They get minimal funding from synagogues, Your Honor. I believe upwards of over 90% to 95% of Maimonides funding comes from tuition, Your Honor.
But the tuition is the result of their recruiting through temples. Isn't this what the record says? Through temples and synagogues and rabbis.
Correct, Your Honor, but let me put it this way. We all know, maybe being members of congregations or temples or churches, how much competition there is for people to come into these entities as parishioners or as to come in and pray. It is unreasonable for this court to consider the fact or to accept the fact that these other temples, these other Orthodox congregations are going to allow Maimonides to come into their facilities and to take their congregations away, to take their congregants away, when Maimonides is arguing that they're a congregation in and of itself.
Yeah, but skip Maimonides out. DET is not saying, taking the position that this school is a church, that it is a school, that it works, as it were, hand in glove with local temples, and suggesting that without if they couldn't work hand in glove with those local temples,
they do not, Your Honor.
Maimonides wouldn't have a student body and wouldn't exist.
That's completely incorrect, Your Honor, and it's against the record. The record tells us that Maimonides is completely independent. It sets its own tuition. It sets its own curriculum. It sets its own religious agenda. It doesn't answer to any other institution. The members of the board that you brought up, Your Honor, for example, and the members that appoint the board members, those are all independent parties.
We'll check the record.
Those are all independent parties, Your Honor. They belong to another. They belong to other congregations in the area. They participate in Maimonides and the Maimonides board as something of their Jewish identity or as goodwill or as charitable work. They don't come from their own congregations as representatives of their congregations into Maimonides and act as representatives of those congregations. They're completely independent.
Thank you.
Thank you.
Mr. Kopak?
Yes, good morning, Your Honors. My name is Michael Kopak, and I represent Maimonides School. And I have agreed to divide my time.
The things I just read off towards the end, about who's on the board and support from the philanthropy and all that kind of stuff, are those all in the record?
Those are all in the record. Leora Joseph, who at the time was the executive vice president of the school, testified to that. She herself is an Orthodox Jew. She had a child in the school at the time who was in the second grade, as I recall, so she was quite personally familiar.
What your adversary is saying is that there's nothing in the record to support this important factor of principal support, or whatever the statutory language is, principally supported. And it seems to me those things I mentioned are all there and support that proposition.
I think they go to the heart of it, Justice Graney. But Mr. Magerer, unfortunately, was right when he read a concession which I had made in the brief on behalf of the school, in which I conceded that there was no principal support. And I must say I now repent of that concession.
Well, what do we do with it now that it's there?
Well, what we do with it is you listen to the Attorney General's argument on that point, because he made a better argument on it than I did, because he marshaled all of the facts which you recited a moment ago on the issue of support.
Let me ask you this. There are difficulties with shoehorning institutions into this. But let's assume, for example, the statute doesn't define principally supported. Okay, and I think your concession may be one that is helpful to the court. It may not help you, but principally supported by a church or convention or association of churches. Okay? Let's assume that I want to start an independent school. Two scenarios. One is I do it to teach, the tenets of the Jewish religion, and religious instruction will be, the core of what's going on in the school. Pretty much, I can run down what the school does. and I advertise in places where I think people who might be interested in that are likely to see the advertisements. So I don't put them on the MBTA. I put them on, I get permission to put them on lampposts that are outside.
Or the Jewish Advocate, the newspaper.
Or the Jewish Advocate or something. And the synagogues have got nothing to do with it. I want to teach the Jewish religion, so I hire rabbinical scholars. I advertise, in rabbinical schools and say, please come and teach. It's no question that what I'm teaching is religious teaching. But there's no church or convention or association of churches that is supporting. I'm recruiting from there. I'm looking only to have Jewish teachers. Do you think in that scenario you get the benefits of 151A, Section 6?
I believe you do, because inevitably your
I think,
students will be drawn from Jewish synagogues.
Yes, but they might be drawn from parents who are not members of a synagogue, for example, but who really want their children to learn about the Jewish religion. They may not be a member of a temple or synagogue.
That's a possibility. But the fact is that if you have rabbinical teachers...
Essentially what you are saying to me is if you're not a church or a convention or an association of churches or an organization which are... when you get to an organization which is operated primarily for religious purposes, that's the place that you may fall into. In other words, I may be a school which is operated primarily for religious purposes. Right? But what you're really saying to me is this contemplates that any religious school, which is wholly independent, may get all of its money only from tuition, as long as it's a religious school. It recruits from wherever, gets the benefit of 151A, Section 6.
I say that because of the free exercise argument, which I have been making in the case from the very beginning, and which was adopted both by the hearing examiner and by the Brookline District Court.
As Justice Sussman suggested, we only get to that
and
if you don't fall clearly within the statute.
I believe you do not have to get to it because I believe the Attorney General's argument about principally supported is correct. However, from the very beginning, I was concerned about the limitation of the statute, and that's why I raised the First Amendment argument.
Okay, so let's say that it's not a Jewish school. It's a hierarchical church school, so Episcopalian, Roman Catholic, the ones that we've recognized as hierarchical, right? I want to teach religious teachings. I recruit graduates of the Episcopal Divinity School in Cambridge or the Western Theological School, which trains Episcopalians. I don't want them as representatives of the church. I want them as people who are deeply learned in the Episcopalian theology. Where do I recruit? Well, I don't know if there's a functional equivalent to the Jewish Advocate, but I'm not asking, Trinity Church. I'm not asking the First Church. I'm not asking any of those to support me. I'm simply recruiting there. Again, I put it on the lampposts outside it. I'm perfectly independent. I may be a 501c3. Why does that get me the benefit of this statute? In other words, why, if it's a free exercise?
If it is a school that is religious in nature and has a religious curriculum, there's a free exercise issue here.
What's the free exercise issue?
The free exercise issue is that people have the right to practice their religion regardless of whether they're associated with a formal congregation. Let's say in the hypothetical that you posited...
They're not practicing religion. They're teaching. They just want to teach. I'm not practicing. I don't have any services. I'm simply teaching.
Unless religion is being taught as solely an academic exercise, separated from practice, it would not be a religious... if that were the case, it would not be a religious school at all, and so it wouldn't even be qualified under this.
It's got to be primarily for religious purposes.
And
primarily for religious purposes.
That's right. That has been conceded here, that we are a religious school, and when you look at the record, you see that the curriculum is permeated with Orthodox Judaism. There's worship and prayer every day. Rabbis are at the head of the school. The purpose of this is to advance not only the teaching of Orthodox Judaism, but the practice of Orthodox Judaism.
The constitutional problem lies, because you are unequivocally a school operated for religious purposes.
That is correct.
So if what was given in the Ursuline Academy case and the other cases to hierarchical churches is taken away from you, there's a very severe problem.
There is, and this is an issue that confronts small religions with small congregations. because obviously, unlike the Roman Catholic Church, which is very predominant in Massachusetts and has large congregations with many students, small religions with small congregations don't have students that can fill a K through 12 curriculum with a full range of subjects to be taught. Therefore, there has to be some banding together in some way, and the customary way of doing it for Orthodox Jews in Massachusetts has been to form wholly independent schools. I understand there are
And
five.
then draw from the network.
Off from the network
That's right.
of
I understand that
churches.
there are 5 Orthodox schools, K through, that teach some elementary, some secondary. We teach both in
So
Massachusetts.
then couldn't we avoid the constitutional problem if we apply the NAMPA theory here and just say that support doesn't mean financial support solely, it can be moral or more than moral in this case, because that's where you draw your people from, and without people you wouldn't get the tuitions. And we'll avoid the constitutional problem that way because you are supported by, whatever the language is, you're principally supported by an association of churches.
I think that's true, and I think association is a broad enough term that it can be applied here, and I think you're absolutely correct that the moral support and the other sort of somewhat financial support and recruiting support that we get and lecturing support that we get is adequate to meet this test, and that would not require you to get to the constitutional issue.
Thank you, Mr. Coppock. Mr. Ogden?
Thank you.
And what he just said is precisely your argument, is it not?
Yes, Your Honor. And let me clarify the record. James Argon on behalf
And
of
you
the
made
division.
no concession that such as
No,
the kind
if-
that might bind him.
That's quite right. The decision issued by the division is very clear on page 2 in the conclusions and reasoning that the hearing officer focused on the key question is whether this organization may be construed to be operated, supervised, controlled, or principally supported by a church or convention or
what is the
association.
church? Why did the hearing reviewing examiner, use the term church community? I mean, it's in quotations, and I just don't know where that comes from.
I think that was reflecting the fact, as Justice Sossman was getting at, that this school does not exist in a vacuum. It is, undisputedly or indisputably, a religious school. And it would not exist but for its religious mission and the support it receives from the Orthodox Jewish community.
But what's the problem with association of churches? I don't mean that you have to have, to me, association of churches doesn't mean a formal incorporated association. It can be a loose association. I mean, I don't know what community gets you that association doesn't get you.
I think the review examiner was attempting to get at the fact that they're addressing the hierarchical arguments that were made by the appellant by looking at that this was much more a religious school that was supported by a congregation of like-minded religious beliefs.
Yeah.
An association,
Right.
essentially. I think he meant it just as
might
a
the word
colloquial
community
term.
that the examiner used be a synonym for association?
Absolutely. I think he meant the
Right.
same exact thing, that it is an association, a congregation of like-minded religious beliefs.
I just don't want an interpretation of the statute, which is why, first of all, he's in quotations. I didn't know from what he was quoting. So first, you don't know from what he's quoting. But second, to me, association doesn't mean a separate 501c3. There are associations. The National Association of Methodist Congregations is a separately incorporated association of many congregations. To me, reading this statute, it says you can have one church, right? You can have a group of churches that informally associate with one another.
That's correct. I think
am I missing something in the statute?
I don't believe you are, Your
Okay.
Honor. I think what the hearing examiner focused on, the review examiner focused on, was this school principally supported by a community of like-minded religious organizations, churches,
Ogden-
synagogues, temples, what have you.
Mr.
It's a very
Ogden-
broadly worded statute.
Can I ask you a second question? From my point of view, unless I'm missing something, whether one's a hierarchical church is wholly irrelevant to this statutory inquiry. There may have been cases that arose because the church was hierarchical, right?
Your Honor is absolutely correct. Prior decisions of this Court, Kendall and
Ursuline.
the Ursuline Academy School, certainly involved a hierarchical church, but there's absolutely nothing in the language of the statute that requires.
And in fact, given the history of this Commonwealth, it would be surprising to me to see that we have statutes that are directed only. How old is the statute?
I don't know when precisely it was adopted, Your Honor.
1935, more or less.
The exclusion was adopted in 1935, is that right?
I can't remember on that,
I
but
mean, I think
it all
that-
traces
Exemption?
back to the Social Security legislation.
But the point here is that certainly the division has never applied it or has never read into the plain language of the statute any such requirement. It
The
is interpreted
the
the statute
hierarchical
broadly.
just makes it easier, because in hierarchical churches, the church literally owns the school and employs everybody. They're employees of the church.
You can't have a Catholic priest. You can have a rabbi, by the way, who is a member of absolutely no congregational synagogue, correct?
That's correct.
You can be a rabbinical teacher. Often you are associated, but you don't have to be, right? I mean, again, I'm simply focusing here, and I don't mean to belabor the point, but the division says, although there's no hierarchical Jewish church, and my answer to that is,
Well, in fairness to the review examiner,
just
what they were focusing on were
He's
the arguments.
distinguishing the other cases.
Well, he was focusing on the arguments that were raised by the appellant. The appellant said, this exemption can't apply because this is not a
I understand,
hierarchical church.
I'm not, but I just want to make sure that I'm not missing anything here.
No, I don't believe you are. Certainly the division has never imposed or read into this statute any such requirement. I think they've taken a very broad view that this exemption applies to any church or convention or association of churches. And it recognizes specifically, this case is a prime example, where it recognizes that there is no such requirement for a hierarchical organization. There may be a spectrum of cases, and as
So,
Justice...
Mr. Ogren, again, I don't mean to cut you off, but I look at the statute, there's an and. Am I missing something if I think in the first part of 151A6R, it's an organization which is operated primarily for religious purposes, correct?
The first part of the test, yes.
Yes. And it is principally supported by an association of churches, correct?
Well, the second clause, I would say, has four different elements to it, one of which the division is relying on here is that organization, which is organized primarily for religious purposes, was principally supported by a church or convention or association.
No, but
of
I'm just
churches.
saying it's not principally supported by a church. This particular case is principally supported
Certainly.
by an association
And
of
I
churches.
think that's what the review examiner was attempting to get at when he used the language of a community of churches. That what they're looking at is that this school derives substantial support from the Orthodox Jewish community in this area. It regards itself as part of the Orthodox Jewish community. It shares common interests with that community. It promotes itself among those synagogues.
Could we use the term association every time you use community? I mean, it's fine, but it's the association of.
Well, it is, and it is more specifically. It's not an amorphous concept. It's a specific right within the Jewish religion for Orthodox Judaism, and that is what the very focus of its association is with. It's with those synagogues. It has rabbis on staff who are in charge of the primary and elementary schools and supervise all the other principals. The purpose of having that, the testimony in the record is clear, is that it's to maintain the integrity of the Orthodox Jewish teachings at the school. It also requires, as Justice Graney pointed out, that the teachers who provide religious instruction must be Orthodox Jews. And in terms of financial support, it receives tuition and payment from the students it recruits from the Orthodox Jewish temples and synagogues in the area. It also, and I'll point out, it does not receive primary funding, but the record demonstrates at Finding 8 and Appendix 218 that in fiscal years 1998 to 2000, the school received nearly $200,000 in direct contributions from Orthodox Jewish synagogues and over $580,000 from combined Jewish philanthropies. Looking at the factors that this court has applied in the Kendall case in Ursuline Academy, it receives administration and operation support from the Orthodox Jewish religion. It is supported by the broader association of Orthodox Jewish temples in the area, and it receives significant financial support. All those factored together, the division reasonably concluded, add up to principal support, and therefore they were entitled to the exemption. And I would stress that what this court is reviewing on a 30A record is whether there was substantial evidence.
Mr. Ogren, could I ask you one more question? And this may be so fundamental that it may reveal greater ignorance on my part than I wish to. Why is Maimonides a defendant here?
Maimonides was sued. The claim was against Maimonides because the employee who was terminated and was not entitled
So they
to
should have been
unemployment
paying
compensation brought
taxes.
suit against Maimonides, saying that they were required to make contributions to
I
the
understand
plan.
that, but here, what this has come down to is whether the decision of the DET was correct.
Yes, and
And I'm trying to get to the, whatever concession Maimonides has made is irrelevant to my determination of whether, under a 30A review, the DET's decision is correct,
I think that's absolutely right. Certainly,
which gave rise to my questions, so that I'm not sure, I mean, it may have, that decision may have collateral consequences. If we decided that the DET was incorrect, then Maimonides may have been doing something that it shouldn't have done.
well, let me answer it this way. I believe Maimonides is a party in interest because if the court ruled adversely to them, they
That's
would
what
have
I'm
to pay
saying.
the employment.
Correct.
But more accurate answer, I think, from our standpoint, would be that certainly the division is not bound by the concessions of either party. The division made a decision. It clearly articulated the basis for its decision was the principal support under the second factor of the test. I would also point, Your Honors, to page 16 of our brief to this Court, which clearly says that is our focus of our argument. Maimonides is exempt because it is a religious school that is principally supported by the Jewish equivalent of a church or convention or association of churches. There has been no waiver on behalf of the
You're
division.
clearly not bound by the concession.
No, I know
and I
that.
think it's just a
don't
matter
even know
of-
why they're here.
Well, I think they're here because they certainly would have an interest in the event this Court would rule adversely.
Sure.
Thank you.
Thank you, Mr. Hoffman.